Very well. Good morning, counsel.
Good morning, Your Honor.
Let me ask that each of you enter your appearance this morning by simply signing in with the clerk. And she will then provide all of that to the court reporter. So all of you who wish to enter an appearance can have that recorded without the necessity of going through that litany that we've been going through during these proceedings. But now, one other point. Is Ms. Pachter, the Attorney General?
She is not here right now, Your Honor.
I beg your pardon.
She is not here right now.
All right. Well, I've entered an order this morning and setting a deadline for a response to the question that I asked her yesterday, or rather at 5 o'clock on Thursday, and then would ask the proponents and plaintiffs to respond with whatever position they have on that issue. Whether it has some bearing on the standing, the issue of standing that we discussed on Wednesday, I am not sure, but at least there's a thought of that rolling around in the back of my mind. And with your able assistance, I'd like to be able to sort through that question.
Very well.
All right. I believe that we're ready to continue the testimony of Ms. Cott?
That's correct, Your Honor.
All right, well, would you bring her forward?
Ms. Cott?
Yes, good morning, Mr. Boutros.
Now, as you've come to the stand, Ms. Cott, let me remind you, you are still under oath. You do understand that?
Yes, Your Honor.
Okay, fine. The oath you took yesterday applies to this testimony as it did yesterday. Mr. Boutros, you may proceed.
Thank you, Your Honor. Good morning, Professor Cott.
Good morning, Mr. Boutros.
Your Honor, before I proceed with the examination, one exhibit issue. I have conferred with Mr. Thompson, and the proponents do not have any objection to the select group of exhibits that were relied upon by Professor Cott in her testimony. So I would move that they be admitted into evidence.
Let's see, those are exhibit numbers.
Well, I could list them for the court if that would be helpful. In fact, I have a list.
All right, why don't you hand that list up to the court clerk?
Yes.
And we'll take care of it. Plaintiffs' exhibits 1308, 1309, 1314, 1316, 1317, 1319, 1322, 1324, 1325, 1326, 1327, 1328, 1334, 1335, 1746, 1750, received in evidence.
Thank you, Your Honor. Your Honor, I would like to publish to the screen another demonstrative I created out of the transcript of Mr. Cooper's opening, and I have labeled it Proponent's Position 2. If we could publish that, please. Professor Cott, I have displayed on the screen one of Mr. Cooper's statements yesterday about the purpose of marriage, and I will read it for the record. Mr. Cooper said that the purpose of the institution of marriage developed in our history the central purpose is to promote procreation and to channel naturally procreative sexual activity between men and women into stable and enduring unions. It is the central, and we would submit, defining purpose of marriage. Now, in your work as a historian, have you examined the purpose of marriage in the United States?
Yes.
Could you give me your views as an expert in the history of marriage in the United States as to that statement by Mr. Cooper in his opening statement?
I could.
Would you do that for me?
Let me begin by saying when I'm speaking of the purposes of marriage, I mean from the point of view of the state that sets up and defines the terms of marriage. And as I look at the history of the institution in our country, I would certainly agree that this is one of the purposes. But it is by no means the central purpose, the central or the defining purpose of marriage. In fact, picking this out, rather when I heard it yesterday, it rather reminded me of the story about the 7 blind men and the elephant, in which each of them is feeling the animal at some side of it. And the one that feels the trunk says, "Oh, this animal is just like a snake." That is, marriage has many purposes. It is, as I mentioned yesterday, a capacious, complex institution. And the state's interest in having sexual activity between men and women channeled into stable unions is one of the purposes of marriages. But I think that the larger understanding of marriage from the state's point of view and the larger purpose would put an emphasis on the household formation that marriage founds, and the stability of that household formation, its contribution to social order, to economic benefit, to governance. And I emphasize this because, as I said at the outset, it's important to recognize the extent to which marriage has been an institution of governance in our history.
Well, let me ask you about that. When you say governance, how is marriage an instrument of governance when it's a union between two people? How does that control the governance?
Looking at this historically, what I'm emphasizing here in using that word is the regulatory purpose of marriage from the state's point of view. And long ago, marriage had an important political governance purpose. It set up men as heads of households who would be responsible economically for their spouses and for any dependents, whether or not they were biological children, adopted children, stepchildren, apprentices, etc. But the point of establishing marriage and giving certain benefits to it was to ensure that the sovereign would be able to govern this amorphous, large, variable population in smaller subunits, which were households. Now that political governance purpose of marriage today has shifted rather dramatically, that is, because we no longer assume that a single head of household governs anyone below it. We have a much more individualized distribution of political power in our population, particularly since 1920, when women got the right to vote. However, still today, the purpose of the state in licensing and incentivizing marriage is to create stable households in which the adults who reside there and are committed to one another by their own consents will support one another as well as their dependents. The institution of marriage has always been at least as much about supporting adults as it has been about supporting children. The proponents emphasize the children.
Well, has the ability or willingness to procreate ever been a litmus test or a test of any kind in terms of the validity of a marriage in the United States during our history?
No.
And has, as a historical matter, has it been recognized that there are other benefits aside from child rearing, benefits from marriage?
Most definitely, from the point of view of the state, as well as the point of view of the individuals who join it. There has never been a requirement that a couple produce children in order to have a valid marriage. Of course, people beyond procreative age have always been allowed to marry, and known sterility or barrenness in a woman has never been a reason not to allow a marriage. In fact, it's a surprise to many people to learn that George Washington, the father of our country, who is often called the father of our country, was sterile and was known to be sterile because he was in a second marriage to a woman who had had children. And after George Washington and she married, they had no children. This was an advantage in many people's minds because he couldn't establish a hereditary monarchy when he became president. But this is just a rather striking example of the extent to which procreative ability has never been a qualification of marriage, nor has it been a ground, the lack of same has never been a ground for divorce.
Now, as a historical matter, has there been a function of marriage, a purpose of marriage, that in terms of legitimizing children?
Yes, this function is not at all as vigorous as it used to be in the longer past, when there was a much stricter line of moral judgment between heterosexual couples who were married and those who were not married, if they were engaging in sexual activity. Certainly the line between legitimacy and illegitimacy for any child born of a heterosexual couple was the line of marriage, non-marriage. And that was a very important function of, particularly among the property, because of the lines of inheritance that would flow through legitimate children, and only problematically, or much less so, through so-called illegitimate children. Now today, in the 20th century, the tendency has been to remove the bright line in terms of the child's just deserts. However, I believe it is still true in our family courts that the marital family's children has the presumption of all benefits that should flow to children. Whereas the unmarried couples have to prove that they deserve their inheritance rights and other benefits of their parents.
Well, yesterday you spoke about the social meaning of marriage. Does the legitimacy factor, in a broader sense, have any connection to the social meaning of marriage as it's developed in our history?
Yes.
Could you describe in what way?
I think I would just say that the fact that the state is involved in granting these kinds of benefits and legitimacy to the marital family, tends to lend a prestige, a status to that institution that no informal marriage has ever approximated.
I would like to, Your Honor, display what I have labeled Proponent's Position 3, which is another statement taken from Mr. Cooper's opening statement as a demonstrative, with the Court's permission.
Very well.
Thank you, Your Honor. Now, here, Professor Cott, I'll read this for the record. Mr. Cooper said that across history and customs, marriage is fundamentally a pro-child institution between a man and a woman. Marriage aims to meet the child's need to be emotionally, morally, practical, and legally affiliated with women and man whose sexual union brought the child into the world. In your view, from a historical perspective, is that a correct and complete description of the purpose of marriage?
No, I think it's a very partial description.
Well, why is it only a partial description?
Well, as I look at the history, I see very little evidence that state authorities considered marriage from the point of view of its pro-child, particularly its pro-biological child advantages. It's not that those advantages were absent, not at all, but rather that the purpose of the state, as I began to say before, and the incentives given to marriage were much broader than this. And the aim to create stable and enduring unions between couples, and so that they would support one another, whether or not they had children, and that they would support the broad range of their dependents, biological children, but others as well. In the longer history of the United States, what we now call blended families, and often think of as a contemporary innovation, such families were extremely common in the past because of early death and remarriage. And many, many families in the past that were maritally based included in them, among their dependents, stepchildren, nieces and nephews whose parents might be absent or dead, maiden aunts, unmarried sisters, aged parents, and the establishment of marital unions and the expectation that the head of the household, or in the 20th century, as we move toward the later 20th century, both heads of household would be responsible for these dependents, has been an extremely central, I would say, purpose of the state's incentivizing of the marriage institution.
Well, does marriage today serve any purposes beyond the purposes that it served at the founding of our country?
I think that the purposes it serves today, one can find roots of these throughout the past, but the emphasis has shifted, I think, in which purposes are more salient, in which now have less emphasis.
Yesterday, we talked about the history of marriage as it related to slavery. I would like to ask you some questions now, going back to that general topic concerning whether marriage laws in the country have always given members of the population equal access to the institution of marriage. Have marriage laws always treated citizens and other members of the population equally and fairly in this country?
No, they have not.
Well, in addition to the restrictions on slaves marrying, do other restrictions come to mind?
Yes. And I think these are more directly relevant than the slave example, which I use simply to illustrate starkly how marriage is, being able to marry is a sign that one has the basic civil rights and ability to consent. But the restrictions on marriage that have played through American history are one major way in which I can show evidence that marriage rules have been used as a mode of governance. And that was, as I mentioned yesterday, in dynamic tension with the extent to which a marriage once formed is a zone of liberty for the partners within it. That, by the way, is the emphasis towards which I think modern marriage has gone. But one of the restrictive examples, there are several I could mention, the most plentiful restrictions, as many as 41 states and territories had for significant periods of their history on marriage between a white person and a person of color. The most plentiful are restrictions that as many as 41 states and territories had for significant periods of their history on marriage between a white person and a person of color. I use that phrase because while these laws originated in the colonies in the 17th century with bars on marriage between whites and so-called Negroes or mulattoes, there were also bars in some states as early as the 17th century on marriage between whites and Indians. And these bars, nullifications, criminalizations, different states treated it differently. These kinds of restrictions multiplied after the Civil War when emancipated slaves could now marry. And while the slavery regime had controlled these marriages to a great extent, there were laws in the antebellum era. After 1865, these laws multiplied across the country. In California and other western states, where there was considerable immigration from people from Asia, there were many laws with many strange descriptive categories. I say strange from our contemporary point of view of Asian ethnic or so-called racial groups, including Malays, Mongolians, Kanakas, and of course Chinese or Japanese. The marriage laws of California and Oregon and a number of our other western states prohibited marriages between whites and persons of these descriptions. Now, these laws, of course, did not prevent any particular white or any particular Asian person from marrying totally. But they did prevent a white person who fell in love with an Asian from marrying that person. And therefore, it was a limitation on partner. It was a limitation of choice. And I want to add that legislators, in passing these laws, of course, hope to reduce the number of them, of such relationships, preventing these marriages. They wanted to reduce the number of such relationships since they could not end in marriage.
Well, let me stop you and ask you about that.
Yeah.
How did legislators and others who advocated these restrictions, how did they justify their fairness and legitimacy in enacting them?
I'll answer that, but if I could just finish my previous sentence, please.
Sure. Your Honor?
Well, it's handy to throw in a question every now and then, Ms. Cott.
I'm sorry. Perhaps I was being too long-winded. The point I wanted to make really was legislators knew these relationships were occurring. They simply did not want to give them the imprimatur of valid marriage. They wanted to make these relationships a second-class sort of relationship, a sort of disfavored relationship, and mark them that way by not giving them the full name and the benefits of marriage.
And given that, how did they, at the same time, justify them to the people of the United States as necessary and legitimate laws and restrictions?
Well, they were usually justified as only natural. That these laws were fulfilling God's plan and the races not mix, that these were obvious, and how could anyone object? They were highly defended as absolutely within nature's plan or God's plan, that certain marriages were right and others were obviously not right. And the legislators, while they of course were enacting the changes themselves, were rhetorically citing larger and higher reasons for their existence.
Your Honor, I would like to publish one more statement from Mr. Cooper's opening, which I'm calling Proponent's Position Number 4, with the Court's permission.
Very well.
Thank you. So, Professor Cutt, in his opening statement, Mr. Cooper declared that racial restrictions were never a definitional feature of the institution of marriage. In your expert view as a historian, does that statement accurately reflect our history?
No, I think it's inaccurate.
Now, these restrictions, the racial restrictions, as you mentioned, were not limited to black and white citizens. I think you mentioned Asians. Were there any particular restrictions that related to Asian Americans and Chinese Americans or people from those areas who were living here?
Yes, this is a complicated history. I'll try to be brief. These were a series of laws passed by Congress from the 1880s on to exclude Chinese laborers from entering the United States. Laborers were the great bulk of those who wanted to immigrate. However, at the time exclusion laws were passed, there were at least 100,000 or more Chinese men residing in the United States who stayed. And there was the question of how they could find marriage partners, since there were very, very few Chinese women. And as I said, around the same time, many Western states, where most of these men lived, passed laws preventing Chinese men from marrying whites, preventing Chinese from marrying whites. Now, that would seem to destine these Chinese men to bachelorhood, which many of them did stay in. However, of course, there were states where there were non-Asian white. There were states where there were not Asian white restrictions. However, added to that in 1907 as part of an immigration law, the federal government made a statement which became law that American women, native-born American citizens, upon marrying foreign men or aliens in the language of immigration law, upon marrying aliens, would lose their own American citizenship. I have to go into this, but this is another kind of restriction placed through marriage policy. In this case, not law, because of course only the states really have the power to pass laws on marriage. But this federal policy said that any American woman who married a foreigner would have to take his citizenship and would lose her American citizenship, even if she was descended from the Mayflower. Now, that was bad enough. But in the case of a woman marrying a German, let's say, if he wanted to become an American citizen, he could. He could go through the naturalization process. He could become an American citizen. And she could, as his spouse, also become an American citizen. He was no longer an alien. But Chinese were regarded as aliens, ineligible for citizenship. That is, not only did the U.S. exclude Chinese and later Japanese and many other Asians, but they prevented those here from ever becoming citizens by naturalization.
Was that a label that, the phrase you just used, the label, that was actually used, aliens ineligible for citizenship?
Yes, I believe, in fact, the state of California invented that phrase in order to designate those who could not own property in California without naming them racially. It was a way to designate exactly which group was meant without a specifically racial designation. And so if I can just finish the train of thought. So an American woman who married a Chinese man, she would not only lose her American citizenship, but would never be able to regain it unless he died. Or I think if she divorced him, she could apply for naturalization. Now that's what seems in retrospect amazing. Now what seems in retrospect amazing restriction on America's Now that what seems in retrospect amazing restriction on American women's citizenship rights because of who they married was actually very strongly fought in the 1920s once women got the right to vote. And it was lifted by a federal act. It was changed in the 1920s, except that the particular extra punishment for women, for American women who married aliens ineligible to citizenship remained. And it was partially lifted for a very small group in the late 1930s, but not entirely lifted until the U.S. became an ally of China in World War II. And the seamliness of the great restrictions on Chinese citizenship and naturalization came to seem not very smart in terms of international alliances and relationships.
As a historical matter, the institution of marriage has generally been regulated by states.
That is right.
And so, was it unusual for the federal government to weigh in on marriage the way that it did regarding Chinese and Asians in the acts you described?
Well, of course, the federal government has the power over immigration and naturalization and matters of national citizenship. And in setting this policy into the 1907 Immigration Act, it seems to me this is one of these cases where the federal government wasn't really very circumspect in looking at how this would have an impact on people and really whether it had the power to do so. Because the law rendered numbers of women stateless, the United States government had no power to say, well, this woman is married to a Russian. After the Bolshevik Revolution, the USSR did not follow the policy that a woman would take her husband's citizenship. So a woman who married someone from the USSR in 1919 would be stateless. She would have lost her American citizenship, and she would not have gained citizenship in the Soviet Union. And there were all sorts of anomalies as a result. And it was, I think I can say in retrospect, it was an extremely misguided policy in many ways. But it was an expression of policy that had a tremendous impact on marriage.
Are you aware of any more recent examples in our history where the federal government has inserted itself into the marriage relationships in the country?
Yes.
Could you give me an example?
I think the major area where this has been the case is with respect to channeling benefits to Americans through the institution of marriage. And a very great move in this direction was taken, of course, in the New Deal, when in the 30s the whole question of citizenship was amplified, and matters of social sufficiency, economic sufficiency were seen as part of citizenship, not only the political right to vote. And so, in the major benefits that were designed and implemented through the Social Security Act, for instance, there was a marital advantage built in, a very distinct marital advantage for those who were married couples as compared to either single individuals or unmarried couples. And since then, with the expansion of federal policies, etc., in the 20th century, the federal government has tended to use the institution of marriage and the marriage-based family as the conduit for benefits of many sorts.
Do you, as a historian, see any parallels between the restrictions relating to race in our country, in our history, in the institution of marriage, and the restrictions that now exist in California concerning individuals of the same gender who wish to marry the person of their choosing?
Yes, I do see parallels.
Could you explain to me, as a historical matter, what parallels you see?
I think that the most direct parallel is that the racially restrictive laws prevented individuals from having complete choice of whom they married, in a way that designated some groups as less worthy than other groups, and some marriages less worthy than other marriages. And it is, and it, as part of the same effort, the same direction. It meant that the informal unions between couples who made that choice would have less honor, less status, fewer benefits, and so on.
Now, at some point, the racial restrictions and the limits of marrying persons across color lines were abolished, correct?
Yes.
And when when that happened, were alarms sounded in the populace regarding what might happen to the institution of marriage?
Yes, these...
Well, could you describe how people reacted and the kind of arguments that were made at the time?
3. First, name the right to marry as a fundamental right. The very next year, in 1924, Virginia passed the most restrictive law in the nation about whites and blacks marrying. Now, there has always been, just by the same token, that these laws were defended as naturally based, and God's plan just being put into positive law. The efforts to undo them were met with extreme alarm among those who thought these laws were correct. And while the question of the constitutionality of these laws could have come before the U.S. Supreme Court earlier than the Supreme Court did decide on that question, because this was thought to be such a hot-button issue and be such a matter of controversy, the U.S. Supreme Court approached it extremely cautiously and did not take it, although they could have taken a case in 1955, which would have brought this issue before the nation. They waited until the case that was decided in 1967, which came from Virginia and from that extremely restrictive law passed in 1924. So yes, there have been all along, there have all along that history was, the subject was extremely controversial. And the people who supported such laws saw these as very important definitional features of who could and should marry and who could not and should not.
Did proponents of those laws argue that the abolition of them would ruin the institution of marriage?
I don't know whether the word ruin was used, but certainly they assumed that should couples across the color lines be admitted to marriage, that the institution would be degraded, that their own marriages would somehow be devalued.
Well, and as a historical matter, in your view, were they correct or incorrect in these assumptions?
I think they were incorrect.
Why is that?
Well, there has been no evidence that the institution of marriage has become less popular because, or less valued by people or by the state. Even though couples needn't, white people can marry whoever they want. So that it doesn't seem to me to have been borne out in the history. And I might also mention that even to date, the proportion of marriages that are across the color line in the United States remains rather small. It tripled in its percentage between, I think in the 1960s, it was about 2% of marriages were across the color line, and by the end of the 20th century, about 6% of marriages were across the color line. Now, while that is a tripling of those marriages, it's also still very, very small proportion of those marriages. And that's worth observing in terms of the alarm about how the change would affect the institution.
Professor Cott, have the marriage laws in the United States, have they ever involved the state, the government, dictating the roles of spouses?
Yes, indeed.
Well, could you tell, is there a term for that role that the state played?
Well, marriage traditionally in the United States came from the common law. And the common law included a doctrine that was called coverture that described what marital roles and duties were.
Why was it called coverture?
Well, this is a word from the Norman French, but it has to do with the fact that upon marriage, the wife was covered, in effect, by her husband's legal and economic identity. And she lost her independent legal and economic individuality. Certainly not her personality. We know that from literature. But she lost her legal and economic individuality, which is really why Jane Doe became Mrs. John Smith. She no longer had her legal individuality as Jane Doe.
Well, how did the states justify that doctrine that took away a woman's individuality and individual status, in essence, once they became married?
Well, this was the marital bargain to which both spouses consented. And it was a reciprocal bargain in which the husband had certain very important and, very important obligations that were enforced by the state. His obligation was to support his wife, provide her with the basic material goods of life, and to do so for their dependents. and her part of the bargain was to serve and obey him, and to lend him all of her property, and also enable him to take all of her earnings and represent her in court or in any sort of legal or economic transaction. And this was a highly asymmetrical bargain that to us today appears to enforce inequality. And I think that judgment is unwarranted. But I do want to stress it was not simply domination and submission. It was a mutual bargain, a reciprocal bargain joined by consent. And it was the state, the common law, and even the positive law that adopted the common law that enforced those terms for the consensual bargain. The couple had to freely consent to it, but the state set the terms.
Was it viewed as, based on assumptions at the time, as sort of a natural division of labor between a man and a woman?
This asymmetricality had everything to do with the sexual division of labor, yes. Because assumptions were, at the time, that men were suited to be providers, were suited for certain sorts of work, whereas women, the weaker sex, were suited to be dependent, needed a stronger hand to guide them, support them, and protect them. Women's work in the household was also extremely important, and the kinds of work that women did and were willing to do were the kinds of work that men would not do, like gardening and milking the cows. This was all very socially conventional. In other cultures, the sexual division of labor might be quite different in terms of what was assigned to which sex, but the sexual division of labor underlay the formation of the marital household. And the reason that a man and a woman were seen to be necessary to form a marital household, so that their complementary tasks and duties and talents would be put in sync and would enable the household to survive.
So did the difference in sexes of marital couples have a connection to and explain, at least in part, what, let me strike that and reframe it. Did the sexual division of labor, does it explain in any manner the sexual differences in marital couples that we've seen through most of our history?
I think yes.
And could you just elaborate on that briefly, please?
Well, I think that at a time period which extended over a very long period of time, and really until the 20th century, when the sexes were seen as so unsuited to the same type of work, and the work of each sex was seen as so particular to the work of men on the one hand, and the work of women on the other, yet both really were seen as crucial to human survival, and particularly to household sufficiency and flourishing, that this was an extremely important reason from the state's point of view to credit and create incentives for the formation of marital households where the population could live and be cared for.
Well, at some point in our history, did the sexual division of roles of spouses, did it come to an end?
Well, in the law, not fully until the 1970s, but that was catching up, I think, with an overall change in the economy and society toward, this is with the development of industrialization, the move away from the agrarian society, the move away from the agrarian society into a society in which work is mechanized, takes place in factories, shops, and so on. And with the direction of social and economic change, as well as a change in values about what is appropriate for each of the two sexes to do, the sexual division of labor became far less rigid. And this was certainly beginning by the late 19th century, but through the 20th century and into our era, the sexual division of labor is no longer necessary for the kinds of work people do in the world. And particularly after the Title VII of the Civil Rights Act, the assignment of spousal roles on the basis of very different proprieties for the sexual division of labor came to seem increasingly archaic. So that in the law, in the 1970s, as part of the more widespread women's rights revolution, the states really, by the Supreme Court decisions, had to step out of this assignment of spousal roles by gender. And this did not, however, in any way reduce the spouse's economic responsibility for one another and their bargain to support one another, which had always been reciprocal, though asymmetrical. So that currently spousal roles are gender neutral in terms of the state's assignments of them. that both spouses are obligated to support one another, but they are not obligated to do one another with a specific emphasis on one spouse being the provider and the other being the dependent.
Do you believe, as an expert, that that move towards gender neutrality in spousal relationships is relevant in terms of the historical development of marriage as it relates to the marriage between individuals of the same gender?
It does seem to me quite relevant, yes.
Why is it relevant?
Well, in the many years when the sexual division of labor and this assumption that the marital couple was an asymmetrical couple with a provider and a dependent, that was quite consistent with marriage between a man and a woman. However, the more symmetrical and gender-neutral spousal roles have become, in fact, I would say in the social world and certainly in the law, the more that the marriage between couples of the same sex seems perfectly capable of fulfilling the purposes of marriage. As it stands today, individual couples are certainly free to have gender asymmetrical roles if they prefer. But that's merely a matter of personal decision. It's not something the state prescribes. The coverture doctrine is dead. It's something up to intimate decision-making. And the presence in marriage and valid marriage of a couple of the same sex fulfills all of the historical purposes of marriage that continue into the present day.
When these changes in gender equality within the marital relationship occurred and began to occur, were there people in society who said that that would have a negative impact on the institution of marriage in this country?
Most definitely.
Well, could you give me an overview of the kind of objections and concerns that were expressed in those ideas?
Well, a century ago, or throughout the entire 19th century, when this became a controversial issue as certain state laws were passed that edged into reducing the coverture doctrine in its entirety, tremendous alarms were raised because the primacy of the husband as the legal and economic representative of the couple and the protector and provider for his wife was seen as absolutely essential to what marriage was. That asymmetry was seen as absolutely essential. And while the initial ways of breaking into that, which were a series of laws that were passed to enable married women to have their own property and then their earnings, while these initial forays raised tremendous alarm, they were motivated really by concern, economic concerns about families' economic stability. They were not in motivation on the part of the legislators about women's equality and individuality. In fact, there were lots of assumptions that the model of marriage, provider, dependent, and so on, with all of its implications about different sex roles, that these would persist. But over time, and particularly as the women's rights movement and the suffrage movement gained steam, and when women gained the right to vote, which was, of course, a very important move towards their legal individuality, the doctrine of coverture came to seem more and more archaic. Still, because there were such alarms about it and such resistance to change in this, what had been seen as quite an essential characteristic of marriage, it took a very, very long time before this trajectory of the removal of the state from prescribing these rigid spousal roles was completed. And in fact, there are instances I could cite, which I won't, of how it recurred in certain decisions and policies in the early 20th century. However, I think I'm fairly confident in saying that because of the Supreme Court decisions in the 1970s, that in terms of the law, that this quality of marriage has been removed to no apparent damage to the institution. And in fact, I think to the benefit of the institution.
Well, let me ask you, in terms of historical trends and changes in the institution of marriage, do you see such trends? Has there been a trend or a trajectory as marriage has developed and the laws have changed?
Well, this is never a straight line. I do think there has been an overall direction of change in the way marriage has been defined and understood and regulated through the states, yes. And that is toward a greater symmetrical understanding of the two partners' roles in the marriage, greater equality of those two partners and fewer restrictions on the choice of marital partner. Therefore, the overall emphasis I mentioned earlier, that certain of the emphases within the purposes of marriage has shifted in terms of their gravity over time. And I think the shift has been toward re-emphasizing the extent to which marriage choice and the zone of privacy and intimacy and familial harmony that marriage ideally should create has been the emphasis on that as a zone of liberty that it should be available to citizens has been more greatly emphasized. Whereas the aspect of marriage as a regulatory and governing institution in which the state is more prescriptive about who should and shouldn't marry and what should go on in a marriage. The direction has been away from governance and toward liberty, although both characters still typify the marriage institution as a whole.
Do you have as a view, based on your historical research and study, as to how those trends bear on the issue of whether individuals of the same gender should have the right to marry?
It does seem to me that that direction of change leans consistently toward the appropriateness of allowing same-sex couples to marry.
Why is that?
Because of gender symmetry and equality and the couple's own definition of spousal roles are characteristic of marriage, then same-sex couples seem perfectly able to fulfill those roles. There is no longer an expectation that the man-woman difference need found a household. Given that the sexual division of labor is no longer so pronounced in our society and isn't, I hope, a founding feature of our economy and how economic benefit is created. And in all those respects, including the respect in which, most importantly, I think, other restrictions on choice of marital partner, other restrictions that seem to have a constitutional question aroused in them, like race, these have been removed. Of course, the state retains its right to restrict access to marriage and still does so in many ways which are not controversial.
You were aware, and I want you to assume that the proponent's witnesses have suggested that if the state authorizes individuals of the same sex to marry, that will damage the institution of marriage and perhaps cause, well, you were aware of that, correct?
I am.
And are you, as a historian, based on your study in your book, and informing your opinions here, are you aware of any basis, empirical basis, to conclude that authorizing individuals of the same gender to marry would increase the divorce rate?
No, not aware.
And are you aware of any evidence that would refute that assertion?
Objection, Your Honor. It's not only leading, but the witness was asked during her deposition whether she was an expert in the consequences of same-sex marriage. And she said, that seems to me an impossible question to answer. And so now she is being asked the question she refused to answer during her deposition, and which is not in her report in any meaningful way.
Your Honor, may I? I'm sorry.
Mr. Boutros?
I'm sorry, I didn't mean to interrupt. It is in her report on page 5 of the rebuttal. On the rebuttal report, and on page 199 of her deposition, Mr. Thompson examined her on the issue of divorce in her home state.
Page 5?
Page 5 of her rebuttal, correct.
But not in the deposition.
It is in the deposition on page 199. She was questioned about that as well.
Let me take a look.
Oh, actually it begins on 198 and then carries over.
It does appear that this subject was explored, at least to some degree, in the deposition. Let me overrule the deposition, or rather the objection, and hear the testimony, and then if necessary you can renew the objection by way of a motion to strike.
Thank you,
Thank
Your
you,
Honor.
Your Honor.
Could you rephrase the question, please?
Yes. Are you aware of any evidence, empirical evidence, that bears on the issue of whether a law allowing individuals of the same gender to marry would affect the divorce rate?
My only comment can come from observation of my own home state of Massachusetts. My only comment can come from observation of my home state of Massachusetts, which has had same-sex marriage for 5 years now. And this is, of course, only a correlation, but Massachusetts has the lowest divorce rate in the nation.
And has it increased since marriage between individuals of the same sex has been recognized?
No, it has fluctuated, but around 1/10 of a percentage point. But if anything, the direction has been down rather than up.
Thank you. To go back to something you mentioned a moment ago, what do you today, based on the collection of events that made up our history as a nation, view as the key defining characteristics of the institution of marriage in the United States?
First, of course, the consent of the two parties, which has been the basis of marriage since the era of the common law, the free consent of the two parties. And I'll just add that in the United States, as compared to Europe, for centuries, that consent has been presumed to rest on a love match, not on any arranged marriage. So mutual consent between partners who freely choose each other and their commitment to establishing a continuing stable relationship as the foundation for a household in which they will economically support one another and their dependents and enable themselves to compose a family.
Do you believe that a law recognizing the ability of individuals of the same sex to marry would be consistent and would include those characteristics you have just identified as being defining?
Yes.
Why?
It seems to me that couples of the same sex have expressed many of the same motivations as couples of different sex to marry and to establish stable households. It seems to me that couples of the same sex have expressed many of the same motivations as couples of different sexes to marry and to establish stable households. And in that regard, especially in an era when families can have children that are not the result of biological procreation, and so many families do, that it seems to me same-sex couples fulfill the aims of marriage from the point of view of the state. And certainly it's up to any partner, intimate pair, to decide whether they wish to be married or not. But it seems to me that by excluding same-sex couples from the ability to marry and to engage in this highly valued institution, that society is actually denying itself another resource for stability and social order.
Your Honor, if I may just check with my colleagues, I think I may have covered the waterfront.
Very well.
No further questions, Your Honor.
Very well.